the prospect of litigation and consequences if we don't follow the law. I just can put it out there. What happens to Measure A?
So I put it out there in 2012. It's probably still on the city website. I don't know how far back those presentations go, but I mean, I stood right here and basically made this argument. You need to adopt this multifamily overlay. I mean, we had a lawsuit pending. We do not want to go down the Pleasanton route. I mean, the worst scenario for the council in 2012 was not doing it, getting the lawsuit, and Measure A being found invalid by a court. That wipes it out for the whole city. What the council did in 2012 is like, we're going to, using the doctor thing, it's like we're doing this very careful 1% incision into the patient to cure the problem. And if the patient says, oh my God, I don't want the 1% incision, well, you may die, patient, so you should do it. I think the multifamily overlay saves Measure A for the other 99%. You take away the multifamily overlay, and I'm not the attorney, and I won't give you legal advice here in front of everybody, then you shouldn't take it from me. But as a planner, take away the multifamily overlay, I think Measure A, its days are numbered. And I would agree. Woody Miner did a presentation in 2007 on the history of Measure A for a big workshop we had on Measure A. We should have him come back and do it again. I mean, that's when I understood Measure A, when he talked about the history of it. And it's obvious. Measure A has done great things for the city.
Is that the legal? I mean,
yes, and let me just
I think this is important.
Yes. So my office did put out a background memorandum on legislative history, which tries to also shed some light on how this works. But without going too deeply into this, the reason that in Alameda we can have Measure A on the books at all is because we're a charter city. And so again, unlike school districts and other counties and other people who are totally creatures of state law, the way the state constitution works is they allow for charter cities, letting the power go as close to the people as possible. And so as a charter city, we are able to control a lot of our own destiny on local matters. And only when the state comes along, which has been pointed out is at a higher level in the food chain than the city is, and the state determines that there is a matter of statewide importance, then it can preempt the city, even in its charter role, from being able to take some particular action, some kind of governance. So Measure A was adopted as part of our charter, which was the city standing up and voting and saying, this is important to our city for all the reasons that you just mentioned, Councilmember Odie. And we all very much appreciate, and I believe the charter is very important to us, and do not lightly ever give up on our charter rights as opposed to something that would be in state law. But I think as it's been made very clear to you here, the density bonus and affordable housing, the state has made incredibly clear, and courts have made incredibly clear, have been determined to be measures of statewide concern. And so in those matters, we have to follow the state law. We have no choice. We will be in violation of the state law. And just like you heard about the city of Pleasanton, who didn't get a housing element adopted, they found themselves having to take their zoning decisions to a court. They paid over $1 million. They couldn't get state funding. They had a horrific problem. So we don't want to go there. And so instead, what we have done, and what my predecessors have done before I got here, is when certain issues came up, like this one, where we have to comply with state law, and we know we will lose, and in fact, on Measure I, we did lose, then what we're doing is what Andrew explained, is what we're doing is we're really reading Measure A to maintain Measure A to the fullest extent, but reconciling it with what is required under state law. And that is why we have said we will approve the waivers. We have explained this to the public, publicly, and to date, no one has challenged us. Now, frankly, in the East Bay Regional Park District lawsuit on the Neptune Point Crab Cove matter, they did challenge it, but that case was dismissed. And so the matter was never determined by a court. But so we have been successful to date in protecting Measure A to the fullest extent possible. But if somebody sues us, we will have to defend, and frankly, we will lose if we do not comply with the state density bonus laws and the state affordable housing laws, and we would risk having a court set aside the entirety of Measure A rather than doing it the way we have been.